Namaste everyone. My name is Dr. Andrea Mikhailovic and I come from University of Montenegro Faculty of Law in Podgorica. The title of my paper is Societas delinquere non potest, Corporate Criminal Liability. The paper discusses crucial aspects of criminal liability of legal entities in the light of the current expansion of economic crime. Most legal systems base criminal liability on the basis of subjective liability, which has resulted in an undefined status of legal entities in the light of criminal liability. The reason for this is the traditional attitude, societas delinquere non potest, taken from Roman law, which is the reason why there has been long resistance in the legal literature and legislation to the idea that legal entities can be subject to criminal liability. On the other hand, rapid globalization and the intensity of the market struggle for survival have resulted in a series of negative phenomena in the field of economic crime. For this reason, the main goal of this paper is to point out the need for adequate regulation of this particularly dangerous form of crime, which in many cases goes undetected and possesses a great threat to social interest in a way that can seriously jeopardize the financial security of the state. Legal theory initially recognized legal subjectivity expresses the ability to be holder of rights and obligations, undertake legal affairs, and be responsible for own actions exclusively to natural persons, taking the position that only human is capable of forming and expressing his own will. The understanding that only people can possess legal subjectivity has left an indelible mark on theories about the legal subjectivity of legal entities. This is obvious even from the terms legal entity or juridical person, which express its dependence on the rule of law as its own creator. That is the reason why legal theory, the emergence of the legal subjectivity of legal entities, was primarily greeted by the theory of negation. The theory of negation does not recognize the subjectivity of legal entities, reducing it to a simple set of natural persons who can be the only holders of rights and obligations. But further evolution of law led to the recognition of fiction's subjectivity to legal entities, well known as fiction theory, since it was considered that only a fiction of the legal order can a set of natural persons be considered as one legal entity, known as a pingatur una persona. Carl Savigny says, only a man is capable of having a will and being a subject in law, and a legal entity is created by the legislator as his fiction. The true recognition of the legal personality of legal entities occurred only in the real entity theory, which treats legal entities as a social fact that must be respected. The real entity theory states that corporation is a being with attributes not found among the humans who are its components. This corporate being, moreover, is a real thing. In particular, it is not the artificial entity of the fiction theory. As we know, the legal entity is not a living being, but a social creation that the rule of law treats as a unique entity different from the natural persons that are part of it. However, in terms of criminal liability, there are differences in the accountability of legal entities in relation to natural persons. The main cause of it is that principle of guilt, which was implemented after the bourgeois revolution in France. And after it was established, it based that individual and subjective responsibility of the perpetrator of crime is the main principle. The original understanding of this principle excluded legal entities from the system of criminal responsibility, since for legal entities there could be no guilt in terms of subjective attitude towards the crime. But the process of industrialization and the seriousness of the consequences caused by the illegal actions of legal entities were increasingly emphasizing the need to introduce criminal liability of legal entities. This first happened in England in the criminal offences of regulatory violations. The case that drew the most attention to this issue was the Queen versus Birmingham and Gloucester in 1842. In that case, the court noted the procedural obstacles to criminal prosecution of corporations